Hello and welcome. My name is Jeremy Glover, and it's my pleasure to welcome you to our latest Fenwick Elliott webinar. This week, we're taking a practical look at arbitration agreements. And remember, arbitration works in both a domestic and international context. So we'll be looking at the essential elements that go into making up the agreement. In other words, what you need to do to make sure and get things right. Joining us this week are two of my colleagues at Fenwick Elliott, Senior Associate Katherine Butler and Olivia Liang. I've been working with both of them on arbitration matters over the past year or so, and therefore I know firsthand that they are perfectly equipped to discuss the topics at issue. They know what they're talking about. So before I hand over to them, just a reminder, you're all on mute. Please do send in any questions, and you should be able to find these slides on our website later in the week. We may even try and put a link in the chat during the webinar. But Katherine, the floor is yours.
Thank you very much, Jeremy, and thank you very much for joining us, everyone. And get ready for what will be a whistle-stop tour of some of the key points concerning arbitration agreements. When parties decide to arbitrate, the arbitration agreement is the bedrock on which the dispute resolution process is built. The decisions which are taken when that agreement is ultimately formed will have huge impacts on how the two sides manage their relationship through disputes. These agreements can also be complicated and mistakes can easily be made. And this can lead to lengthy and costly satellite disputes, not about the underlying contract, but about the arbitration agreement itself. To ensure that we're all alive to these issues and can successfully navigate the pitfalls, Olivia and I are going to take you through the headline issues concerning arbitration agreements. I will start by talking about the why, the where, and the when, in terms of the reasons to arbitrate as the choice to resolve your disputes. And I will then go on to look at the agreement itself, its validity, and some important features to be aware of. Following on, Olivia is going to focus on the what in terms of the elements to be included in any good arbitration agreement, as well as the who, primarily in respect of the arbitrators themselves. So there's a lot of ground to cover, and so without further ado, let's get into it. Sorry, there we go. Hopefully that will stay. As always, a good place to start is with a definition. And the Arbitration Act states that arbitration agreement is an agreement to submit to arbitration present or future disputes, whether they are contractual or not. The New York Convention, 1958, which we will talk a bit more about later, offers an expanded definition and highlights some key features that we should look into in a bit more detail. Firstly, it is an agreement freely entered into by all parties and in writing. This written requirement is mandated by both the Arbitration Act and the New York Convention, and I'm not aware of any jurisdiction which will allow you to have an arbitration agreement that is entirely oral. Secondly, the agreement should relate to any and all differences, current and future, in respect of a defined legal relationship. This means that the agreement should be sufficiently broad to respond to any dispute which has or could arise in the future. And both definitions refer to disputes that are contractual or otherwise. This is designed to ensure that you don't have dual systems of dispute resolution, whereby claims that are strictly contractual are resolved by arbitration, and other claims, such as under tort or equitable claims, are referred to national courts, notwithstanding that they arise from the same relationship or contract. Also, the subject matter of the dispute must be arbitrable. This means being capable of resolution by arbitration. Arbitration is a private process, and therefore it's not possible to use this type of dispute resolution when it comes to public rights, matters of public policy, or otherwise determining the rights of third parties. A further important point to note about these definitions relates to when an arbitration agreement is entered into. They refer to present disputes and differences which have arisen, as well as future disputes. This is to encompass any disputes that are current at the point the arbitration agreement is made, and means that these agreements do not necessarily need to be entered into at the point the underlying contract is, but these can be formed at a later point once a dispute has arisen, if the parties so wish. So, with pretty universal access to national courts, it's a purposeful choice to take disputes through an agreed private process. Now, it used to be considered that there was the potential for time and cost savings by taking disputes to arbitration, but now it's pretty recognised that the phases of an arbitration pretty much mirror the time that it can take a litigation to go through to trial. And arbitration is not inexpensive, with arbitrator and arbitral body fees generally being higher than you would be charged through court fees. So if it takes as long and costs the same, if not more, why do it? Well, a lot of parties do. The 2021 White & Case International Arbitration Survey found that international arbitration is the preferred method of resolving cross-border disputes for 90% of respondents. Now, the reasons for this high uptake relate to party control, neutrality, enforcement, and confidentiality, and I'll go through each of these in a bit more detail. Unlike in the court system, parties retain much more control over the process of an arbitration. Now, this can range from the choice of institutional rules, which will govern the arbitration, such as the ICC or the LCIA, to choice of arbitrators, which Olivia will talk about a little later on. Now, this level of party control is present at the outset and throughout an arbitration process, because arbitrators will generally seek to direct by consent. Unlike the courts, judges, whose appointment is the luck of the draw, they have the option to be much more top-down in their case management rather than referring to party autonomy. Neutrality can be a very important factor when dealing with international disputes, because nobody is going to want to give the other side any home turf advantage by having the dispute heard in their local court. Arbitration allows for disputes to be dealt with under international rules by a multinational tribunal in a mutually acceptable venue. Regarding enforcement, there are rules in place for the recognition by national courts of a judgment of a foreign court. For instance, the CPR Part 74 deals with enforcement of foreign judgments in England and Wales. However, these rules are dependent on various bilateral and multilateral treaties, such as the Hague Convention or the Brussels Convention between EU member states. And the process is complicated. Alternatively, the New York Convention, 1958, is an excellent example of international comity in respect to the recognition and enforcement of foreign arbitral awards. The convention offers, with the proper evidence being provided and subject to very limited defences, an established process to have an arbitral award enforced by courts outside the jurisdiction where it was decided. And there are currently 169 contracting states signed up to the New York Convention, which represents over 86% of countries on the planet, with the ultimate aim of dispute resolution being to actually enforce rights and entitlements. This is a major advantage for enterprises or projects that have international dimensions. And finally, the ability to keep the process, determination, and even the existence of a dispute private and confidential is an important draw for many commercial enterprises. In the courts, unless the very high threshold for keeping proceedings confidential is met, all evidence and arguments presented will be matters of public record. Whilst it is often assumed that arbitral proceedings are confidential, the reality is not so straightforward. This is one of the potential pitfalls that we need to be aware of. In England and Wales, the parties and the tribunal are always under implied duties to maintain the confidentiality of a hearing, documents generated or disclosed during the proceedings, and the award. Now, this implied duty comes from the common law because the Arbitration Act is silent on confidentiality. Now, the English courts have long recognised this duty, and this was affirmed by the Court of Appeal in Ali Shipping. However, this case does not impose a blanket duty of confidentiality on arbitral proceedings, and the court set out certain exceptions, such as disclosure by consent, or where keeping that information private would go against the interests of justice and or public policy. The position becomes less clear, as I've offered some examples on the slide, when you look at how confidentiality is dealt with in other jurisdictions. So overall, the takeaway in respect of confidentiality is that it is not a given. If keeping potential disputes and the information surrounding them private is a key factor in the choice to arbitrate, this needs to be addressed up front. This means the arbitration agreement should include express duties of confidentiality or otherwise include these by reference to specific institutional rules. For example, the LCIA, CIAC, or HKIC rules all include detailed and broad duties of confidentiality, which the arbitrators are given significant powers to enforce. To note, the ICC takes a different approach and makes it a matter for the parties to request confidentiality orders, but they do also offer a model confidentiality agreement, which the parties can choose to enter into. So, moving on to the agreement itself, valid arbitration agreements will be enforced unless, as described at Article 2.3 of the New York Convention, the agreement is null, void, inoperative, or incapable of being performed. What constitutes null, void, inoperative, or incapable of being performed is a subject all of its own, but it should be noted that the English courts take a pro-arbitration stance. This stance was recently demonstrated by the Court of Appeal's decision in Ad Active and Ingroulet. Apologies for pronunciation of that word if it's very wrong. Here, the court gave effect to an arbitration agreement containing a seemingly inconsistent jurisdiction clause. In doing so, it declined to enforce a decision of an American court on the basis that such proceedings were brought in breach of the arbitration agreement. Now, not only does this highlight the importance of a clearly drafted dispute resolution clause, but also shows the English court's respect for the election to arbitrate and its willingness to give effect to contractual terms wherever possible. Key point to note is that the courts will take pains to ensure that the parties' agreement to arbitrate is binding and that recourse through the national courts is limited. In England and Wales specifically, the courts are empowered to restrain litigation proceedings which should otherwise be referred to arbitration. As set out at Section 9 of the Arbitration Act, judicial discretion is extremely limited and the court must stay any such proceedings brought in contravention of a valid arbitration agreement. Take note, once you've decided to resolve your disputes via arbitration, in the vast majority of cases, you will be held to it. So, on to the where. As mentioned previously, arbitration agreements must be in writing, but they do not necessarily have to form part of the underlying contract. Commercial agreements will commonly include provisions for dispute resolution, and if the parties choose to arbitrate, this can simply be a clause in that contract. Alternatively, and as envisaged by Section 6.2 of the Arbitration Act, an arbitration agreement can be incorporated by reference. This is another potential pitfall, as you may not offer sufficiently clear terms of incorporation or reference, and therefore the agreement to arbitrate will not be valid. Now, whether or not the parties have actually incorporated an arbitration agreement by reference is a matter of construction of the clause in question under the applicable law. Focusing on the English law approach, once again, a pro-arbitration stance is taken, whereby general words of incorporation will be sufficient. And this was held by the Court of Appeal in Modern Building and Limmer and Trinidad. Here, it stayed proceedings brought in breach of an arbitration agreement. However, the courts will only uphold written agreements to arbitrate where they can find them. Now, this was not the case in Lisnave and Chemicalian, where the formal contract simply made no reference to the document containing the arbitration clause that one side was seeking to rely on. So, insofar as general words of incorporation go, this can only be stretched so far. Further issue to be wary of is generally in relation to what are called two contract cases. This is where competing terms of reference or competing dispute resolution clauses are evident. This is often encountered where there is an arbitration clause which is contained in a secondary contract to which one or indeed both of the primary contracting parties is not a party. This was seen in Barrier and Redhall, where it was deemed unfair to allow a party without notice of the terms of the secondary contract to unknowingly give up its resort to national courts. However, in this case, it was alternatively argued that there was an arbitration clause in the respondent's standard terms, which had been incorporated with general words of incorporation, and the court agreed. So, you may have noticed that I've been referring to underlying contracts and arbitration agreements, and this is because they are two separate contracts, and that is important to remember. The arbitration agreement is collateral to the underlying contract, which forms and governs the legal relationship from which any of the disputes will arise. This brings us on to the doctrine of severability. As clearly stated at Section 7 of the Arbitration Act, unless expressly excluded by the parties, an arbitration agreement is distinct and remains valid even when the underlying contract is invalid or did not come into existence or has become ineffective. The operation of this section was discussed in the seminal case of Fiona Trust and Privilov from the House of Lords in 2007. Here it was held that the status of the arbitration agreement would only be impugned where the grounds of the invalidity complained of applied directly to the arbitration agreement itself rather than the underlying contract. Take the example of a contract which includes an arbitration clause is claimed to have been entered into by misrepresentation. Now, whether or not that contract should ultimately be rescinded because of the misrepresentation is an arbitral matter. And unless the misrepresentation claimed relates directly to the terms of the arbitration clause, which feels unlikely, that agreement will stand. Specifically, their lordships considered that, quote, if any businessman did want to exclude disputes about the validity of a contract, it would be comparatively easy to do so. So it is therefore in the power of the parties to agree to arbitrate and thereafter expressly cater for the disputes which are going to be encompassed by that agreement. Once that election is made, and absent specific and limited circumstances, this is the process that they will have to follow, even if the underlying contract ends up being completely and utterly null and void. So I can catch my breath, I am now going to pass over to Olivia, and she's going to discuss what should actually go into your arbitration agreement.
Thanks for that, Katherine. So what I'd like to turn to now are the core elements of an arbitration agreement, or in other words, the key decisions that you'll need to make in the course of agreeing to arbitrate. At the outset, it's probably worth mentioning that there's no shortage of poorly drafted arbitration clauses out there. That's partly because dispute resolution is rarely at the top of the priorities for parties when they're negotiating a contract, and it's also because the arbitration agreement is often found towards the end of a contract and dealt with in a rush at the final stages. So the end result is that parties are often stuck with arbitration clauses that are cut and pasted from pre-existing agreements, with only limited consideration of whether these actually work for that particular contract and those particular parties. And that can cause extensive and expensive confusion as to what the parties actually intended if and when a dispute arises. So hopefully we can provide you with a brief rundown of some of the main things you'll need to consider when you're agreeing an arbitration clause. To begin with, one of the most important decisions you'll need to make is the seat of the arbitration. The seat is the legal home of the arbitration, which determines which country's procedural laws will apply. So when you choose a seat, you're essentially placing your entire arbitral process within the framework of one state's national laws. In practice, this means that the seat will determine key matters such as the extent to which local national courts will support or supervise the arbitration, the availability of any interim measures, and the grounds on which an award from the tribunal can be challenged before local courts. So hopefully it's clear that the choice of one seat over another could have real consequences for the parties to an arbitration, both procedurally and also in terms of final results. When selecting a seat, there are several factors to bear in mind, which I've listed on the slide. But if I would choose 3 factors, I'd say the most important ones are, first, the formal legal infrastructure in the seat. You want to select a seat with a clear framework in place for facilitating arbitration, which places limits on court intervention and has a good track record of neutrality and impartiality. Second, whether the seat has an independent and competent judiciary with experience in international arbitration. And third, whether the jurisdiction is signed up to the New York Convention, as this will determine whether the tribunal's award can be recognised and enforced. So some of the most widely used seats are London, Paris, Hong Kong, Singapore, and Geneva. Another element to consider is the law of the arbitration agreement. So as Katherine has already explained, an arbitration agreement is separable from the contract that it's contained in. So that means it's possible for an arbitration agreement to be governed by a different law to the law of the underlying contract. The law of the arbitration agreement will determine any questions as to its validity, scope, and its interpretation. So while it might seem like overkill, it's worth expressly specifying the governing law of the arbitration agreement. If you don't do this, and a dispute arises as to, say, the validity of the arbitration agreement, the tribunal, or maybe sometimes the court, will need to decide which law applies. So normally this will come down to 2 possibilities, either the law governing the underlying contract or the law of the seat. However, this is still a bit of a grey area, and there's no clear consensus internationally on which is the right approach. So the UK Supreme Court recently set out no less than 9 principles to govern determination of a law applicable to an arbitration agreement. Broadly summarised, if the parties have made an agreement on a choice of law for the underlying contract, this will generally be interpreted as applying to the arbitration agreement. But if there's no choice of law for the arbitration clause, the arbitration agreement will be governed by the law with which it's most closely connected, and this will generally be the law of the seat, even if this differs from the law applicable to the parties' substantive contractual obligations. On the other hand, there are several cases in other jurisdictions which tend to suggest that the law of the seat is the most appropriate law for the arbitration agreement. So, on balance, it will be best in most cases to avoid any uncertainty by expressly selecting the law of the arbitration agreement. This is especially important if the law of the arbitration agreement is going to be different from that of the seat or the law of the underlying contract. From a drafting perspective, you could either do this by 1, ensuring that the governing law clause in the contract expressly refers to the arbitration agreement, or alternatively by drafting an express choice of law in the actual arbitration clause. Another decision you'll need to make is the scope of what you actually want to refer to arbitration. So for most contracts, the parties will intend to resolve all disputes arising under the contract by arbitration. So the default approach would be to keep the scope as broad as possible with no carve-outs. That could be accomplished by using wording which refers all disputes arising out of or in connection with the present contract. That's the case with the model clauses from the International Chamber of Commerce and the London Court of International Arbitration, both of which I've extracted on the slide. One of the benefits of using a broad arbitration clause is to avoid disputes from being dealt with across different forums. That could arise in a situation where you have one dispute being dealt with in arbitration and another related dispute being addressed in a national court. And it should go without saying that this sort of fragmentation can be expensive and time-consuming, but can also give rise to some inconsistent results. There are some instances where parties might validly want to carve out specific disputes from the scope of the arbitration agreement. So typical candidates might be disputes relating to technical evaluation points, which might be finally resolved by expert determination. But if that's the position, you should give long and careful thought as to the delineation of what disputes you intend to carve out. If the boundary of the carve-out is fuzzy, you might end up in long disputes over what does and doesn't fall to be decided in arbitration. So, in most cases, parties will simply be better off if they agree a broad arbitration clause with no carve-outs or limitations, not least because it can be nigh on impossible to predict the nature of all disputes that might arise under a long-running agreement. You'll also need to decide whether to opt for institutional or ad hoc arbitration. In an institutional arbitration, the arbitration is administered by a specialist arbitral institution under its own rules. Some of the most important arbitral institutions are the International Chamber of Commerce in Paris, the London Court of International Arbitration, and the Singapore International Arbitration Centre, and each of these will have their own set of arbitration rules. By contrast, in ad hoc arbitration, arbitral institutions are not involved. That means that there's no supervision or support from any institution over the conduct of the proceedings, and the parties, at least in theory, have complete freedom to choose their own rules and procedures, subject to mandatory procedure requirements of the seat, and they'll also need to determine all aspects of the arbitration themselves. Sometimes, to save time and money, parties to ad hoc arbitrations choose to incorporate or modify existing rules of arbitration procedure instead of inventing a completely new one, so the UNSTRL rules are among the most popular option. So the natural question which arises is, which is better, institutional or ad hoc arbitration? And I think the answer to that is that it depends. So there are, unsurprisingly, advantages and disadvantages to both, and you'll need to make your choice based on the party's particular circumstances and the amount that's likely to be at stake. So beginning with institutional arbitration, the most obvious advantage of institutional arbitration is that there will be a pre-established set of rules and procedures which saves parties the time and expense of trying to negotiate these themselves and allows parties to benefit from a tried and tested formats. The institution can also provide administrative and specialized assistance in case problems arise during the procedure, and depending on the institution, the award may be scrutinized by the institution's court, which could help to maintain standards. One of the main disadvantages of institutional arbitration is that the assistance of the institution isn't free, so parties will have to pay administrative fees for services, and that amount could be considerable, especially because these fees are often set as a percentage of the value in dispute. There might also be bureaucracy from within the institution, and which could lead to delays and a certain lack of flexibility in terms of procedure. As for ad hoc arbitration, an obvious advantage is that there are no administration fees, which means that the parties only need to pay fees to their lawyers and their arbitrators. So ad hoc arbitration might be more suitable for smaller claims. The other main advantage is that the process is completely adaptable, and in principle, that means the parties and the tribunal are completely in control. The disadvantages of ad hoc arbitration are that if the parties do not decide to abide by a pre-existing set of rules, it can be very difficult to agree procedures after a dispute has already arisen. And further, the lack of support from an institution also means that it's easier for parties to frustrate proceedings by, for example, delaying or refusing to appoint an arbitrator. And that in turn raises the risk that the parties want to seek recourse from local courts. From a practical perspective, what that all means is that ad hoc arbitrations are not necessarily cheaper than institutional arbitrations. They can be more cost-effective, but that will depend on factors which might be hard to control, such as the willingness of the parties to cooperate, whether the parties are experienced in arbitration, and the quality and experience of the appointed arbitrators. Another element to consider expressly including in an arbitration clause is the language of the arbitration. This is especially important if there's any possibility that this might be open for debate because, for example, the project is international and the individuals involved all speak different languages. As a general rule, the language should be that of the underlying contract and/or the majority of the documents, not least because of the cost of obtaining translations. The last key element I want to cover relates to arbitrator selection. The arbitration agreement should address the number of arbitrators, the appointment of arbitrators, and potentially any qualifications that the arbitrators should be required to hold. And there are a myriad of options for each of these. In almost all cases, the tribunal will consist of either 1 or 3 arbitrators. Arbitration with a sole arbitrator is generally cheaper than using 3 in terms of the savings on fees. But the downside of having only 1 arbitrator is that if the parties can't each nominate an arbitrator, and they're putting all of their eggs in the one proverbial basket. So for that reason, it's normal for high value and complex disputes to have 3 arbitrators. Parties can also set out a method for appointing arbitrators in the arbitration agreement. In most cases, sole arbitrators are selected by agreement, or if no agreement is reached within a specified time, by a chosen appointment authority, such as an arbitral institution. If there are to be 3 arbitrators, 2 of them are usually nominated by the parties, with the third being chosen by 2 party-nominated arbitrators or by an appointing authority. And in those instances, the third arbitrator will often be the chairperson or president of the tribunal. It's also possible to require the arbitrators to have certain qualifications and to include these in the arbitration agreement. Parties might, for example, want individuals with a minimum number of years' experience in a specific industry, or to place restrictions on nationality. There are, however, some risks with being too prescriptive on this front, because you might end up significantly limiting the available pool of arbitrators. But on the other hand, a lack of clarity over qualifications could pose its own problems and create grounds for challenge. So an example of this might be a requirement to appoint an individual with a minimum number of years' experience in industry in circumstances where the clause fails to specify whether that would include experience working on behalf of that industry, such as a lawyer or other advisor. Ultimately, the selection of any arbitrator will come down to several factors, including the arbitrator's legal background, as well as feedback from the parties' lawyers. So the arbitration clause should ideally set a framework for arbitrator selection, which doesn't unduly limit the pool of candidates who might be available to act. So now that we've covered the core elements of arbitration agreements, we've also listed some other considerations, which unfortunately we don't have time to cover in any detail. So one consideration is whether a multi-tiered arbitration clause would be suitable. These are clauses which require the parties to attempt mediation, negotiations, or some other form of ADR before commencing arbitration. They're fairly common on construction projects and they contain standard forms, such as the FIDIC suite. Another option is to consider including an express reference to the procedural rules to govern evidence taking in the arbitration, and a popular example of that is references to the IBA rules. You should also consider whether you're likely to need the ability to join third parties to an arbitration or to consolidate 2 or more separate arbitral proceedings. Many of the most popular institutional rules have provisions which address both joinder and consolidation. But in practice, arbitration is a creature of consent, and an arbitral tribunal's powers to order joinder and consolidation are usually subject to many more restrictions than would be the case with the national court. So having counted through that list of other things to consider, it's worth wrapping up by considering some general principles. I think the first is that parties should think really carefully about whether arbitration is actually right for them. In some cases, arbitration might not actually have that many advantages over litigation, where, for example, there are minimal concerns with enforcement because the parties' assets are in the same jurisdiction, or where the ability to join in other parties without their consent is actually very important. So it will always be very necessary to consider a party's particular circumstances and objectives before settling on arbitration. The second principle is that parties should give proper care and attention to drafting arbitration agreements, because they will be held to them with potentially far-reaching consequences. There's no guarantee that a clause that has worked well in previous projects can simply be transferred over with minimal amendments. That means that parties should consider the arbitration agreement early on in contract negotiations, as dealing with the arbitration clause at the 11th hour will usually only decrease choice and flexibility. Having said that, it's important to resist the temptation to draft a very prescriptive clause which seeks to cover every possible eventuality. That can have its own pitfalls if the provision is so complicated that the parties will struggle to actually comply with it. Finally, to conclude, you'll be forgiven for thinking that these tips are simply good practice for any dispute resolution clause. But in our experience, the principles and concepts behind arbitration agreements are hard to master, and it's often worth taking specialist legal advice before committing.
Thank you. Thank you both. And obviously, I think we have there 2 specialists who you could quite comfortably go to for that advice. But thank you, a very clear toolbox exposition of some of the principles. It's something that's often neglected, as I think you both suggested at the outset. We've had quite a few questions come in, and one thing. Well, actually, one question that came in, Olivia, before you actually mentioned it, in relation to multi-tiered arbitration clauses, and I know that you just sort of touched on them briefly, but a person was actually wondering if you've got any tips for drafting an escalation clause.
Thanks, Jeremy. I think the most important tip is to make sure that the parties' obligations on mediation or any other form of ADR are actually set out with sufficient certainty. So we should make it clear in each instance that every step has been complied with. And a really important part of this is to include time limits so that the parties can't indefinitely drag out the different steps before actually being able to refer the dispute to arbitration. And it's also a good idea to use mandatory language such as must rather than may.
Okay, no, thank you. I mean, because I think whatever contracts you find now, you refer to sort of the FIDIC, which has got its own the DAB procedures, but lots of contracts have their own bespoke processes, whether it's senior management, because I mean everyone recognises, I suppose, the importance of dispute avoidance and try and see what you can do to avoid arbitration. But then you see in the courts all these issues about oh well, they haven't done it properly, they haven't taken all the steps properly, and I think the suggestions you've made about clarity and the use of words such as must is incredibly important. And I think perhaps sometimes it's because sort of there's a certain unfamiliarity with sort of construction clients when it comes to arbitration. And interestingly, sort of one or two sort of general points and comments that have come in. I suppose asking about common misconceptions and when it comes to arbitration or using arbitration in construction contracts. And I don't know, Katherine, if you've got any sort of comment on that. No.
Yeah, I mean, misconceptions, if it's not a process that you're particularly familiar with, I think there are some lingering assumptions about it. One, as I mentioned, relates to cost, and as Olivia touched on, some of the arbitral body fees can appear eye-watering when you can compare them to the court. But I think the main one is the point on confidentiality that I raised, because you really cannot take that for granted. And even though in this jurisdiction there is an implied duty of confidentiality for arbitral proceedings, that is like the minimum level of protection. And the case I mentioned, which I'm just going to get back to my slides, in alley shipping, that those exceptions have been applied on various occasions. So it's not an absolute duty. And particularly if you're not in this jurisdiction, that really needs to be a consideration. As I mentioned, the Australian case of ESSO Australian Resources, in that case, they said there is no implied duty of confidentiality in arbitration. And following that case, the International Arbitration Act in Australia was amended to actually include a duty of confidentiality as a basic obligation. But then you compare that with Sweden and the US cases where they've said there's no international consensus on what confidentiality means or how it's to be applied. And unlike in Australia, the Swedish Supreme Court is hard over that unless you expressly incorporate duties of confidentiality in your arbitration agreements, they won't be imposed. So you need to understand, do I want it to be confidential? Am I having this heard in a jurisdiction which implies a duty? And if not, include for it expressly. And I would encourage everyone to include for it expressly in any event, just to give you that added layer of protection.
No, the top tip at the end. So no, thank you very much. And it's almost a webinar in itself, perhaps. So, but think that time is now drawing to a close. So it just leaves me to thank you, Katherine, thank you, Olivia, again, for your very clear setting out sort of some of the things that we all need to think about when it comes to drafting arbitration agreements. The most important one actually being to think about it. It seems, and just leaves me to just remind everyone we've got a final webinar for 2021 coming up on Thursday, 9th of December, when Lucinda Robinson, partner at Fenwick Elliott, will be joined by Felicity Dines, a barrister at Atkin Chambers, and they're going to be looking at damages for defects. So thank you very much for joining us today. Hopefully you'll be able to join us in a fortnight's time. So thank you very much and goodbye.